left out his name, Mr. Morara.
Thank you. I think we now have all the appearances. You will allow me, on behalf of my brother and sister judges of the Supreme Court, to first of all say a very good morning to all of you, and also to welcome all of you to these proceedings. I wish to recognize our distinguished guests who have joined us this morning, recognizing the Honorable Retired Chief Justice Othman Chande, and your entire delegation of eminent African jurists who have come to observe these proceedings. You're very welcome. I wish to also recognize the parties who are present, the petitioners, the respondents, their friends and supporters who are watching us online. Unfortunately, due to constrained space that we are operating from, we could not accommodate very many people. You can all see we are all required to observe the COVID-19 protocols. We also have to be mindful of security and the constrained time, and therefore we were forced to limit the number of the counsel who can appear at any given time. But parties are free and at liberty to have as many counsel as they could. We'll try to accommodate as many as we can in the speed of a room, court number 1, where they can follow the proceedings and continue assisting counsel who are in the plenary. We thank the media also for coming to stream the proceedings online to assist Kenyans and all people from all over the world who are watching and following these proceedings across Africa and across the world. We specifically, I want to thank the observers who have come to be part of this process to attest that we are all guided by the rule of law, constitutionalism, values that we all share across Africa and indeed in the Commonwealth and all over the world. And also to express the judicial solidarity for us, which is a core emblem which cuts across the border as we attempt to develop our jurisprudence and work together in the spirit of bilateralism and regionalism. We therefore welcome you to Kenya to these proceedings. Today, counsel and parties, we are here for the pre-trial of the election petitions that were filed before us. As you are aware, 9 petitions were filed, and we received 25 preliminary issues in form of interlocutory applications. We have been able to dispose of all those preliminary issues and delivered rulings online, which I believe you are still reading and internalizing. After we dealt with the preliminaries, 2 petitions were struck out petition number petition number E006 and petition number E009 was struck out, and the rulings were delivered together with the media summary showing the reasons why they were struck out. So we are left with 7 petitions, and the court has considered the 7 petitions which emanate from the same presidential election which was held on the 9th of August 2022. So upon perusing and considering the issues raised in the following petitions, E001, E002, E003, E004, E005, E007, and E008 of 2022, and the respondents thereto, we find that all those petitions raise similar issues and seek similar orders. Therefore, we order that petitions numbers E001, 2, 3, 4, 5, 7, and 8 of 2022 be and are hereby consolidated with petition number E005 of 2022, which is designated as the RIND presidential election petition for 2022. The parties will therefore be, the ending of the matter will therefore read as Raila Odinga and Martha Karua will be the first petitioners. John Njoroge Kamau will be the second petitioner. Youth Advocacy Africa and Peter Kilika will be the third petitioner. Kerif Karifa, John Josewe, Ruth Mumbi, Grace Kamau, David Kariuki will be the fourth petitioner. Okia Umtata Okoiti, Nyakina Wycliffe Gisebe, Victor Okuna, John Maina will be the sixth petitioner. Julia Nyokabi Chege, Joseph Mutua Ndonga, Simon Mwaura Njenga will be the seventh petitioner. The respondents will be William Ruto and Rigathi Gachagua, the first and second respondents. IBC will be the third respondent. Then Mr. Wafula Chebukati, fourth respondent. Juliana Cherera, fifth respondent. Irene Masiti, sixth respondent. Justice Nyangaya, seventh respondent. Francis Wanderi, eighth respondent. Professor Gurie, ninth respondent. Boya Moru, 10th respondent. And the Attorney General will be the 11th respondent. From the rulings that we delivered, we have admitted Law Society of Kenya as amicus curiae or amici curiae with ICJ, Mr. John Warubengo, Dr. Joseph Savira, and Martin Milero. That is the order of the court for the consolidation of the matter. So the other issue that we are going to deal with this morning upon consolidation of the matter is to settle the issues for determination. The court, having considered the printings that were filed, the submissions, and all the documents that were filed, we have framed 9 issues that have been shared with you by now, I believe, but I'll read them out. The first issue is whether the technology deployed by IEBC for the conduct of the 2022 general elections met the standards of integrity, verifiability, security, and transparency to guarantee accurate and verifiable results. Issue number 2, whether there was interference with the uploading and transmission of Forms 34A from the polling stations to the IEBC public portal. Issue number 3, whether there was a difference between Forms 34As uploaded on the IEBC public portal and Forms 34As received at the National Tallying Center, and Forms 34As issued to the agents at the polling stations. Issue number 4, whether the postponement of gubernatorial elections in Kakamega and Mombasa counties, parliamentary elections in Kitui Rural, Kacheriba, Rongai, and Pokot South constituencies, and electoral wards in Nyaki West in North Imenti constituency, and Kwanjenga in Embakasi South constituency, resulted in voter suppression to the detriment of the petitioners in petition number E005 of 2022. Number 5, whether there were unexplained discrepancies between the votes cast for presidential candidates and other elective positions. Issue number 6, whether the IEBC carried out the verification, tallying, and declaration of results in accordance with the provisions of Article 138(3)(c) and 138(10) of the Constitution. Issue number 7, whether the declared president-elect attained 50% plus 1 vote of the votes cast in accordance with Article 138(4) of the Constitution. And number 8, whether there were irregularities and illegalities of such magnitude as to affect the final result of the presidential election. And finally, what reliefs and orders can this court grant or issue? Those were the issues that the court has come up with. Perhaps then we can proceed to the next area. Council present and parties, considering the constitutional time frame for determining the consolidated presidential election petition and the nature of the issues raised, as well as the COVID-19 pandemic, we have limited the number of advocates who can sit in the plenary as per the schedule that was shared with you this morning by the registrar of the court. For further clarity, been asked to clarify that parties have a right to representation of as many lawyers as they wish. The only reason we cannot accommodate everybody here is because of the limited space. We are still in the COVID-19 protocol that requires social distancing, and also because of security. However, on account of all these considerations, we have facilitated additional advocates to sit in courtroom number 1, where the proceedings will be streamed live. I will seek your indulgence on behalf of my brother and sister judges and cooperation in this regard. We have also shared a time allocation that is allocated to each one of you. I believe you have been given a copy of the time allocation schedule. Things are streaming online. If you can check, maybe it has come, but I can read it for you. When we will start the hearing tomorrow, the main petitioner, that is petition number E005 of 2022, Raila Odinga and Martha Karua, we have allocated them 3 hours. The supporting petitioners, being petition number E001 of 2022, John Joroge Kamau, we have allocated that supporting petitioner 30 minutes. Petition number E002 of 2022, Youth Advocacy Africa and Peter Kirika, we have allocated 30 minutes. Petition number E003 of 2022, Kerif Karifa and others, 30 minutes. Petition number E004 of 2022, David Kariuki Ngari, 30 minutes. Petition number E007 of 2022, Okia Omtata Okoiti and others, 30 minutes. Petition number E008 of 2022, Julia Nyokabi and others, we have allocated them 30 minutes. It is hoped that that will be the time allocation for tomorrow, and when we proceed to the hearing of the Okay. We've also looked at the responses by some respondents, namely Juliana Cherera, Irene Masit, Justus Nyangaya, and Francis Wanderi, who appear to be supporting the petition. These 4 respondents have been allocated 1 hour to share among themselves. That gives to that 15 minutes each if they are represented by different council. Then parties in opposition to the petitions, we have identified IMBC together with the chairman, Wafula Chebukati, and we have allocated them 3 hours to share. William Ruto and Rigathi Gachagua, they have been given 3 hours. The Attorney General will be given 30 minutes to respond. According to the rulings that we have delivered, we admitted 3 amici curiae. They will not be given time to make oral submissions. According to the rules of this court, we will rely on their briefs, which are on record, unless the bench wishes to raise an issue for clarification by them. That will take us now, the 2nd day of the hearing. We are hoping the 3rd day, which is Friday, we will hear a rejoinder. We'll give the main petitioner in petition number E005 of 2022, Raila Odinga and Martha Karua, 1 hour to respond. Petition number 001 of 2022, John Joroge, will have 15 minutes. Petition number E002 of 2022, Youth Advocacy Africa, 15 minutes. Petition number E003 of 2022, 15 minutes. Petition number E004 of 2022, 15 minutes. And petition number E007 of 2022, 15 minutes. And petition number E006 will also have 15 minutes. As you will also have noticed, we have given a comprehensive ruling on the applications that were filed seeking discovery, various discovery and scrutiny. According to the order that has been issued, we are expecting a report that will be tabled before this court for consideration by Thursday afternoon. And if there will be issues arising from that report, we have agreed to give the main petitioner 30 minutes to respond. And because they filed an application for discovery, so was Youth Advocacy Africa and Mr. Kerif, they also filed an application for discovery. According to the issues that they were raising, the Youth Advocacy will be given 20 minutes, and Kerif, who was seeking 1 issue, will be given 10 minutes. The IBC will be given 30 minutes, and William Ruto and Rigathi Gachagua will also be given 30 minutes to respond to the report that will be filed if there will be issues arising which they will wish to respond to. That is the time allocation. Due to the time constraints that we have to determine these election petitions within 14 days, we will appreciate also the filing was tight within 7 days. This is dealing with information or evidence from all over the country. The framers of our constitution decided that they will give 14 days. It has been done before, and we hope to do it also this time. But we will also seek your indulgence when you are allocated your time, you will adhere to the time. We also developed some ground rules as a court where we are requesting that parties and advocates will observe punctuality, the time that is indicated for us to start the proceedings, and the time allocated to them on the screen. We will also, this is an old practice, that we will continue to be respectful of the court, our personnel, and also to respect each other, adhering to the rules of this court. We also are obliged to state that we expect parties to conduct themselves with decorum to preserve the dignity of the court and the proceedings, while bearing in mind the provisions of Section 28 of the Supreme Court Act. We are also reminding ourselves that these are judicial proceedings being conducted in court, and therefore discussing the merits of the case by the parties or counsel outside the court is not permitted. We still have the power under Section 28 of the Supreme Court Act to cite such parties who are in violation of the provision of the law. We also like to remind you that courtesy must be observed at all the time. The court will not tolerate offensive language. We like to repeat about the time allocated due to the time constraints. Once a party has exhausted the allocated time, the microphone will be switched off. We also wish to state that if there is time that is unspent by the council, the time belongs to court, so we will not allow anybody to donate, but revert it to the court for the court to share it out according to the court's generosity or lack of it. Due to the limited timelines, there will be no extension of time, so please let no one ask for extension of time. We are dealing with the submissions that have already been filed. We have been painstakingly reading those submissions. Therefore, we wish parties to just focus on the key issues that they would like to highlight. Parties are therefore urged to focus on the pertinent points of their case to save on time. We always like to remind parties cell phones must be switched off or on silent mode. During the hearing, unnecessary movement or disruption when the court is in session is discouraged. However, parties or counsel or even the bench are however permitted to take health breaks during proceedings as the need may arise without disrupting the continuity of the submissions. And during these individual breaks, the proceedings will proceed. Even if I want to walk out, don't think the proceedings have stopped. They will proceed. The media present, we have already issued the media guidelines that must be observed all the time. Given the immense public interest in the proceedings, we have allowed media houses to run broadcasts, live broadcasts to enable Kenyans to follow the process from any part of the country and even beyond. We urge members of the public to follow the court proceedings from the comfort of their homes or offices through their television and stream broadcasts without the need of coming to court physically. This is particularly informed by the reality that due to the limited space within the court premises, we can only accommodate a limited number of persons to attend the proceedings in person. Consequently, we have restricted physical access to the court premises only to the persons who have been accredited as parties, counsel, or court personnel. We will also urge the counsel, when you're making your submissions, any references made to the material. You can see the voluminous nature of the files. They are still in our chambers. Please, we ask you to specify the bundle and the page that you'll be referring to for ease of reference. If there is any electronic presentation to be made, we would kindly request that it is provided to the registrar of the court 30 minutes before the commencement of the day's hearing. As I have said before, court number 1 has been prepared as a spillover room to accommodate parties and the advocates. We are also reminded by the Ministry of Health to continue reminding ourselves of the COVID-19 protocols and regulations which will apply in the course of the proceedings. We urge parties to cooperate and comply with these directions. I think that is all from the court.